We have two cases for argument this morning, Minnesota Voter Alliance versus Ramsey County and Olmsted County, and McReynolds versus the state of Minnesota. We'll take Minnesota Voter Alliance first. Mr. Joseph, you've reserved 10 minutes for rebuttal? All right. You may proceed when you're ready. Council will give each of you 3 minutes of time uninterrupted at the beginning of your argument. And then at the 3-minute mark, I will interrupt you and see if members of the court have questions. You may proceed.
Thanks. Good morning. May it please the court, counsel. My name is Greg Joseph. I represent the Minnesota Voters Alliance, the Republican Party of the state of Minnesota, and several individuals dedicated to restoring integrity to Minnesota elections. And make no mistake, the state of elections in Minnesota is dire. The legislature drafted 203B-121 to ensure a fair, balanced, and uniform process to accept and reject absentee ballots. Instead, we have a piecemeal administration of elections, contradictory application of relevant statutes, and a total lack of uniformity, balance, and fairness, which is precisely the scenario the legislature sought to prevent. Unless this court remedies this situation, the practical result will be that no elections in Minnesota are fair, as they will continue to be dictated by the party in power and not by the carefully crafted statutes designed to ensure what we are asking for, which is that all elections be administered fairly. The case before the court involves two completely different approaches by two different counties, each of which turns 203B-121 inside out. The introductory clause requiring a governing body to establish a ballot board has been interpreted by Ramsey County as allowing it to choose whomever it wants, to count the votes. Ramsey County has also somehow separated the idea of establishing a ballot board from actually putting people on a ballot board. This is completely inconsistent with 203B-121 and the accompanying statutes 204B-19 through 22. This has led to a total disaster, including deputizing local staffers who are beholden to the candidates on the ballots they count, and ignoring the requirement in 204B-21 that party lists of election judges be exhausted prior to the appointment of any other ballot board members. But if Ramsey County has misapplied a portion of 203B-121, Olmsted County has completely obliterated it. They've shown no regard for party lists at all. The clear language that a ballot board must consist of election judges has been applied as meaning 0 election judges may be an appropriate and acceptable number, something both counties agree upon. The ballot board in Olmsted County is made up entirely of hand-picked staff, dubbed deputies, pursuant to unknown authority, and solely for the purpose of occupying the ballot board. These counties, by exempting deputies from the mandatory qualifications for election judges in 204B-19 through 22, have opened the door to candidates, their spouses, parents, and children making the decisions to accept or reject ballots with their own name on them. This must be stopped. The bottom line is this. Ramsey and Olmsted counties are asking you to recognize authority to appoint who they want to accept and reject ballots, and not who they're required to appoint.
Council, let me just stop you and see if members of the court have questions. Justice Anderson.
Council, you argue, and the Center of the American Experiment argues in its brief as well, the counties didn't appoint any election judges, but my view of the record seems to suggest that they did, including some of the named petitioners here. Were these illegitimate appointments? Were there in fact appointments? What's your view of the record on this point?
Your Honor, I guess the better way to say it would have been that the governing bodies did not appoint election judges in Ramsey County. They delegated that authority to the county auditor, who did so.
So you are not disputing that, in fact, there were election judges appointed in Ramsey County?
Correct.
Let me ask you about the argument about that delegation, now that you've mentioned it. It looks to me like it was not raised at the Court of Appeals. Is that true? And do we have a forfeiture issue here relative to that argument?
Your Honor, what I would say to the court is that I think all of these ideas are intertwined. This is a statutory interpretation case, Your Honor. So I think at the heart of it, I think this court has an obligation to get the interpretation correct. So to the extent that the delegation issue itself wasn't raised, we certainly did talk about composition of the ballot board, how it's appropriately made up, and I think that's the heart of this case, Your Honor.
Is your argument fundamentally a question of ambiguity, or is it a plain language analysis from your perspective?
I think it's both, Your Honor. I think there are clear duties that are established by the statute, but I think there are ambiguities as well. And I think it's a question of how we're going to interpret and apply those ambiguities. I think we have to say that any deputies that participate on these ballot boards have to be qualified the same way election judges are qualified under 204B 19 through 22. I don't think there's any way to interpret this. There's no clear directive that that's how they be qualified, Your Honor, but I think that's the only way to read the statute.
Questions, but I'll yield to my colleagues at the moment.
Counsel, in your view, what is a sufficient number of election judges?
I think, Your Honor, that's up to the individual counties and local governing bodies. That number won't be the same for everyone. A sufficient number is a sufficient number to accept or reject all of the absentee ballots that come in.
Does it depend really at bottom on how big the county is, how many absentee ballots they're faced with counting? Is that really what it depends on?
That's my reading of the statute, Your Honor. And now, that doesn't mean they have authority to remedy the shortage that they create. That means they have to appoint a sufficient number to accept and reject all the ballots, which will vary by county, Your Honor.
Does it make any difference that in the duties, there's kind of a broad duty of the members of the board to accept or reject ballots, and then there's a specific duty of election judges specifically if there's a question of Social Security's numbers or driver's license being numbers correct to compare signatures? So, I mean, is the election judge, it seems like sufficiency has to be defined by the duties. I don't think you'd disagree with that. So, but which duty is it? Why is it not just the duty for election judges, just the duty that's specifically called out for election judges?
So I think what you're asking, Your Honor, is, are we talking about separate classes of people? Are we talking about one class of people who are election judges who will accept and reject ballots under subdivision?
I suppose that assumption is underlying the question.
Okay,
yes.
right. So we would argue that any deputies that are appointed, which again should be a minimal number of people, okay, it's optional and discretionary whether any deputies are appropriate at all. But if they are included, then they have to be qualified the same way an election judge is qualified if they're going to be accepting and rejecting ballots under subdivision 2 and in 203B121.
And just assume for a minute that we don't accept that argument. And so the election judges and the deputy auditors are kind of separate entities within this member as being members of the board. Do you agree that the purpose has to, the duties are going to should define what sufficiency is? Like you need enough, I think that's your essential argument, is you need enough election judges to perform the duties listed in the statute.
Correct.
That's what defines sufficiency. And I guess I don't need to go any further. That's helpful. Thank you.
Okay. Thank you, Judge.
Counsel, on that sufficiency issue, if it's up to the counties, as you've indicated, and it depends on the particular circumstances, couldn't that number be 0? I mean, that's essentially what Olmsted County says is, well, we did just what Mr. Joseph is telling us we need to do. We assessed our own situation and determined that a sufficient number was none.
So
why isn't that plausible?
So we have a couple problems with that, Your Honor. And the first problem is we have to reconcile the number 0 somehow with the language in the second clause, which is it must consist of a sufficient number of election judges. Okay. Now, I think the most useful way to answer your question, the easiest way to illustrate it, is by looking at 204B 45. 204B45 is the small town and mail-in ballot statute. The language in 204B45, by contrast, provides two things that 203B121 does not. Namely, we see the language in subdivision 2, the board may consist of deputy county auditors or deputy municipal clerks. So we're expressly allowing a ballot board comprised solely of deputies, okay? The second piece of that that's absent in 203B121 is we have the second portion of that sentence which says who do not need to be affiliated with a major political party. And that goes back to the party declaration requirements in 203B1 or 204B21, Your Honor. So I think the application, what we're seeing these counties do, is closer to the language in 204B45 than it is to 203B121. So it's a roundabout way of answering, okay, but the answer is we have to get around this idea in the statute that the ballot board must consist of election judges.
But counsel, I don't know how that helps your argument because you still have to deal with the word sufficient. And I don't understand how you can say that sufficient doesn't or can't equal zero.
So we have to look back to see what the purpose of 203B121 is. Why are we creating this ballot board? Why are we putting these people on this board? And the answer is to accept and reject absentee ballots. The idea was to create a process that was as balanced as it could be with representatives from the major political parties to make decisions whether we accept or reject these ballots. So the word sufficient can only mean sufficient to accomplish the goals of the statute, which are to accept or reject all of the absentee ballots. So the local governing body can determine what the sufficient number is to do that, okay, but creating this division between election judges and a separate set of rules for deputies, which we don't find anywhere in 203B121 or 204B19 through 22, okay, can't be consistent
But
with the
counsel,
intention.
doesn't the statute itself create those two divisions? Because it seems to me just a plain reading of it, as your opponents say, is it talks about the board must consist of a sufficient number of election judges trained and appointed per 204B, but that language is absent when you get to the very next sentence that talks about deputy county auditors. And so the statute itself seems to have set up these two different groups of people who are appointed in two different ways.
So the third sentence, really the language we see about deputies in the third sentence is orphaned language. We don't see that language anywhere else, anywhere. We don't see any specific procedure for appointment. And that's why we argue that 204B19 through 22, that's the process we have to use.
But maybe isn't that by design?
I beg your pardon?
But isn't that possibly by design, that there is no that the legislature did that purposely?
And if that's the case, we would have to see authority come from somewhere. And that's why we talked about 38408 and what the county auditor is authorized to do under 38408.
Why does the authority have to come from somewhere other than the plain language itself?
203B121 doesn't have any language that authorizes the appointment of deputy county auditors. It authorizes inclusion of deputy county auditors on the ballot board, but the actual appointment is absent here. So the closest we can come is 38408. But otherwise, we're talking about the exercise of local authority. We're talking about a local charter, or we're talking about the statute that Ramsey County cited, which is 37302, which would allow the dog catcher to make decisions about accepting and rejecting ballots. So the only thing that makes sense, the only thing that's consistent with the rest of the statute is that we treat these deputies as consistent with the appointment process in 204B21, which lays out that after the party list has been exhausted, the legislature provides two additional ways to appoint people to ballot boards.
Counsel, can I ask, thank you, that's helpful.
Yeah.
That's very helpful. I just want to ask sort of a broad, big picture question. And it seems to me that underlying your entire argument is this idea that, and I heard it in your opening statement as well, this idea that party balance is what is the key to this, is the key to 203B, it's the key to all of our election laws, it's what makes elections fair, it's what provides integrity, and that it's sort of baked in. I mean, you didn't use those words, but it's baked into this process, and that's why we can interpret the statute 203 the way that you're saying. But when you look at the amicus brief, particularly from the Secretary of State, he says that premise is you're proceeding from a false assumption. That's not the premise. That it's more about, there's no partisan balance, baked into this. That it's more about elected officials appointing whom they deem to be proper to handle this process. And I'm just curious about your general reaction to that broad theme, because I think, it's like one person's on Venus and the other's on Mars here in terms of what this whole thing is supposed to accomplish.
Right, I understand. Thank you, Judge. So I think there are a couple things that jump out. First of all, I would argue that the most critical function of the absentee ballot board is the decision to accept or reject ballots. I think a lot of 203B121 is set up in sort of a supporting fashion. We see a lot of subdivisions talking about what to do with ballots once they've been accepted, or where to bring them, or who sorts them out. But the decision to accept or reject is critical. And we see unequivocally in 203B121 in subdivision 2, the requirement that those performing the most critical element of this statute have to be party balanced. We also see in 204B21 the requirement that those appointed to be election judges must be party balanced. I don't know how we get around those two requirements. I think those are unequivocal on the part of the legislature. I think they're indicating clearly that we're not going to be able to find people who are truly nonpartisan or unbiased. It's not going to happen, particularly in today's environment. So I think, yeah, sure.
I'm sorry.
No, I was just finished my thoughts, Your Honor, if I could.
I thought you were almost done, so I didn't mean to interrupt. But no, I wanted to ask you about the legislature, amended section 203B.121 and many other election laws after the Court of Appeals decision came out. And it clarified that the training that members of the ballot boards must receive, but it didn't impose any additional requirements on the appointment of deputy county auditors. So I know that wasn't a decision by this court, but doesn't that suggest that the Court of Appeals interpretation was correct, or it comported with the legislature's intent?
Your Honor, I guess what I would say is I'd note for the court that we're not adding any new duties with the amendment. We're not really changing anything. We're not adding any new responsibilities or privileges for deputies. So it has been changed, but the fundamental statute hasn't changed much, Your Honor.
If I understand your argument, is it that the main constraint on the county's discretion on whether to use deputies or partisan election judges is the must language in the second sentence of .121?
The must language, so we're arguing that the ballot board must consist of election judges. The only thing that's up for question is what the sufficient number of election judges is. And again, we're arguing that to satisfy the statute, the intent of the statute is a sufficient number means sufficient to accept or reject all of the ballots.
And then I just have a question about the relief that you're seeking now. I mean, we don't have an impending election. There'll be one soon, but can you comment on that?
Sure. The relief we're seeking is we're asking the court to direct that the ballot board must consist of election judges who are making these decisions. And if there are going to be any deputies who are included pursuant to the third clause, that they have to be qualified the same way election judges are. And that means they have to meet all of the requirements in 204B19 through 204B22, including we don't appoint any deputies until the party list has been exhausted, that the two major political parties, all the political parties have furnished. I didn't mean to exclude the two marijuana parties, Your Honor. And we have to have declaration of party as well, as required by 204B21.
So what do you do with the language I think it's a subdivision 2 that specifically says election judges performing the duties must be of different major political parties, not referring to the deputies and also not referring to members. So it calls out, I mean, it's kind of similar to the other statutes you were referring to before, where it made that distinction in the language. How do we get around that?
Sure. So I would say we're back to whether we're creating two classes or not. So the members of the ballot board, I would say, Your Honor, as this statute was originally drafted, members of the ballot board meant all election judges. I mean, we see in 2013, the amendment where we crossed out staff, okay? Right. Now we have deputies here. But originally this was meant to be all election judges. So we have the language in subdivision 2, the members of the ballot board marking it accepted or rejected. But I don't think this refers to two separate classes of people because there's nothing else in this statute that
So your argument really relies on the fact that all members have to qualify as election judges. That's how you win. And if that is not the case, then there's a lot more question here.
Well, then we have more moving parts. And then I would expect to see the duties more clearly delineated. If we would see a set of duties for election judges to perform some tasks and a separate set of duties for deputies to perform a different set of tasks, I would expect to see some language to that effect.
Well, we do have the one specific election judge task, which is to compare signatures.
Right. Then the question becomes, is that also going to mean that deputies are forbidden from performing?
I would think it would. I would think that's what that would mean, yes.
So then we would have to somehow be identifying members of the ballot board.
I mean, it's one of the reasons Olmsted's argument that you don't have any election judges doesn't make any sense to me, because there's a specific duty for election judges under any argument.
Right.
So, okay, that's how, can I just ask a kind of a different question?
Sure.
Is there any case where we have found if we find a statute ambiguous, this is kind of related to the mandamus requirements, where we found a statute ambiguous, can that statute be stating a clear duty? So does the ambiguity create a lack of clarity, or is our interpretation, if we find even an ambiguous statute creates a duty, then that's a clear enough duty? So is there any cases that address that question?
Sure, there is, Your Honor, there is a case, and I apologize, I don't have the citation. Okay. I'd be happy to provide that to court, but ambiguity does not preclude a grant of mandamus, Your Honor.
Does it matter here, Olmsted County makes the argument, they say they're not required to, but they inquired as to partisan balance. Does that matter here?
Well, it's certainly notable that they asked for it on paper. Unfortunately, they didn't follow any of the other strictures in 204B19 through 21, or 21, Your Honor, 22, I apologize. But yes, it is notable that they're requiring that of their deputies the same way they're requiring it of their election judges.
Let me ask you sort of a global question here, and I'm going to ask opposing counsel the sort of the obverse of this. Why isn't the analysis correct that what we've got here is, so Minnesota adopts the Australian ballot maybe about 120 years ago, give or take a little bit. And for much of that period of time, voting is in person and partisan election judges are the rule of the day. I don't know when that requirement comes in, but it's a very long time ago. Now, just in the last couple of election cycles, we've seen an increase in mail-in ballots, absentee ballots, and the legislation just simply hasn't caught up in terms of dealing with the changed circumstances. Why isn't this ultimately a legislative question for the legislature to address, as opposed to having the court to step in and say, this is the preferred policy that should be applied here, given the absence of any language that specifically does what you suggested should be done here?
And I think what the legislature, thank you, Your Honor, I think what the legislature is trying to do is to create a framework that takes it out of the idea of partisanship. I think that's what we see here. And I think historically it was the party in power that determined how the ballots were counted. And I think the legislature's intention in drafting 203B121, for all its warts and lack of clarity, was to try to create a system that rose above that partisanship fighting. And I think we have some remnants that are, we're not going to pretend there's no ambiguity, Your Honor, there is. So we have some remnants and some amendments that make it difficult to interpret in some ways. But I think the intention here is to put it above politics. I think that's what we see from legislature.
Does, there's some reference, I mean, I think it's probably in the legislative history partly, but that these deputy auditors take some kind of oath of office that makes them nonpartisan. And I couldn't figure out what oath says that they have to be nonpartisan. Can you help me with that?
No, I'm sorry, Your
I mean,
Honor,
I'll
I
ask the
can't.
opposing counsel.
That's part of the problem with the county's argument is the deputies in the third sentence really are being appointed pursuant to some authority we just don't know. There's nothing here in 203B121. And 38408, which is the deputy county auditor statute, tells us that a county auditor can appoint these deputies to perform the duties of the county auditor in the county auditor's absence. And interestingly, 412-151 is the deputy city clerk statute, which authorizes one deputy city clerk. And we have examples in other cases of hundreds of these people being appointed. But we don't know what authority we're talking about. And once you introduce local charters or local authority, you're introducing piecemeal administration of elections, which is exactly what we sought to prevent in this statewide context. And it's really different. We can draw a line between local town elections for local elected officials and city elections, which are conducted separately from statewide elections. But for statewide elections, we have to have the same administration for all cities and counties.
Thank you, counsel. Your time has expired. We'll see you on rebuttal. Now, respondents, as I understand it, you're splitting your argument. Mr. Roach, you're taking 13 minutes, and Ms. Plant, you're taking 12. So we'll take the 3 minutes off yours, Mr. Roach. In other words, you'll get 3 minutes uninterrupted, and then I'll stop you and ask for questions.
Good morning, Your Honors. May it please the Court, I'm Assistant Ramsey County Attorney Robert Roach on behalf of Ramsey County. Counsel for Appellant has argued this case as if it is a declaratory judgment action, that there's some need to come in and clarify what he has conceded is ambiguous law. But they chose to bring a mandamus action, not a declaratory judgment action. And mandamus requires a clear and unambiguous legal duty. As this Court has said, to meet that requirement of establishing a clear legal duty, it will only be satisfied when the petitioner has shown a legal right which is so clear and complete as not to admit any reasonable controversy. In a former life, I was an Army officer, and I had a sergeant who would put that standard in lay terms as, it's got to be smack you in the face obvious, no question. Petitioners did not even come close to meeting that exacting standard in this case. We've had 3 appellate judges, a district court judge, and the chief elections officer for the state of Minnesota say the counties are doing it right. I respectfully submit that on this record, it cannot reasonably be concluded that the duty is so unambiguous that no reasonable mind could disagree with it. Turning to the question of the delegation of authority to make appointments to the Ramsey County Ballot Board. 4 points. First, they did waive it. It was not raised to the Court of Appeals, and it was not raised in their petition for review. They offered no response to our waiver argument in their reply brief to this Court. I respectfully submit that this issue is therefore not properly before this Court. If the Court chooses to reach it, the Court should find that the delegation was proper. There is nothing in the election statutes that says a board must make the actual appointments to an election, to a ballot board. There's no violation of a clear legal duty. Ramsey County unquestionably established its board. The resolution is in the record. There's no requirement that every single election judge must then be brought before the board and hired by the board. The case law and statute cited in our brief support our assertion that those appointments to the ballot board do not fall within the extremely limited category of non-delegable duties. even assuming, arguendo, that those appointments should have been made by the board and not by the county auditor, mandamus is still not appropriate because they haven't even pretended to show how they suffered a peculiar harm, different from the general public, by the fact that the appointments to our ballot board were made by our auditor rather than our board. Turning to the question of a sufficient number of election judges. That issue is also waived. It was not presented to the Court of Appeals, and it was not in the petition for review. I would also point out that here, they're asking this court to reverse a denial of mandamus based on a hypothetical. The hypothetical is that there were no election judges on Olmsted's board or on our board, but the record clearly says there were. We had 67 election judges in Ramsey County.
I'm just going to stop you and see if members of the court have questions.
Counsel, in both your brief and I think the Secretary's brief, a great deal is made of the fact that there are alternative remedies that might be available here, including a declaratory judgment action. And you specifically said a few minutes ago that that's really what this is all about. But aren't we here on this proceeding because the declaratory judgment actions failed on standing grounds? I mean, in other words, isn't that argument essentially they should go back and try an argument that's already been rejected?
No, Your Honor, respectfully, it is not. And the reason is they never tried it. There have been declaratory judgment actions in other elections cases that failed, but as to my knowledge, they never tried to file a declaratory judgment action on this specific issues raised before this court. I'm not aware of any case where a declaratory judgment action has been filed.
Let me ask you the obverse of the question that I asked opposing counsel, which is, if you look at the historic pattern here for decades at least, partisan election judges are used to supervise the counting of ballots, but not in the context of mail-in ballots or absentee ballots, which historically have been a relatively small number of ballots. That's now changed, and it looks like the model that's being used is inconsistent with what the legislature has historically required. Does that in any way influence the result here?
No, Your Honor.
And shouldn't we be concerned about the fact that we have, we don't have a partisan check on what could be partisan counting?
I'm going to try to answer that question in a couple of parts because I think there are several parts of the question. One, no, I don't believe that what is happening is in any way inconsistent with what the legislature intended. In Ramsey County, we had a ballot board of 67 people. 5 were deputies. They were there to fill in when others were not available. The vast majority of the counting and accepting and rejecting was done by a balanced partisan ballot board. So I do not believe that the way that Ramsey County did it in any way conflicted with legislative intent. 2, in terms of whether the court should change, let me rephrase that. Even if the ballots were being counted exclusively by deputies, which is not what happened here, that would not be violative of the statute. And respectfully, it is the province of the legislature to craft the election code in this state. If there is a problem that needs to be solved, that problem should be addressed by the legislature. The legislature drafted a statute that says you can have election judges, or you can do deputies, or you can do both. And it is respectfully not the place of this court to craft the election code for Ramsey County. If that problem is to be solved, it's to be solved by the political branch.
Counsel, if I may, 2 questions. One, where did you get the 67 election judges? I mean, it sounds like what I understood from your brief is you exhausted the party list, but then what did Ramsey County do? And then I have a follow-up question. Where'd you get them, and what was the process that you got them through?
I'm going off memory, Your Honor, based on the record below. In my recollection, I had an affidavit from my head elections person, is they do have nonpartisan election judges. So election judges can do a declaration of a member, I affiliate with this major party or that major party, or I'm unaffiliated. When Ramsey County exhausts its list from the 4 major parties, it has a roster of unaffiliated election judges. They call them and say, are you available to serve in a precinct or on the ballot board? Does that answer your question, Your Honor?
It does. Where do they get that list?
From people who have done it before, people who have signed up and expressed an interest in doing it, I believe, Your Honor.
Okay.
You know, they keep records of who's done it, and then they reach out and say, will you please come back?
Okay. Thank you. That's helpful. And then secondly, You answered a little bit in response to Justice Anderson, this question. It sounds like you, as much like Olmsted County, your read of the statute is you don't have to have any election judges. Am I hearing you correctly? You did, but your point is you don't have to.
Yes, Your Honor, that Ramsey County's position is that they are not legally required to have election judges, but I would follow that up with the idea of this court doesn't issue advisory opinions.
Well, stop that. I agree with you there, certainly. But my question is, how do you square that with subdivision 2B3? And I think this was part of Justice Thiessen's question. How do you square that with subdivision 2B3, which says there is a part of the statute when the signatures don't match up that specifically calls for election judges to be involved? You got to have some then, right? There's got to be at least some. There can't be none.
Your Honor, my response to that is I do believe that the first part of the statute does create at least a hypothetical scenario where you might have a sufficiently small number of absentee ballots rolling in that the work could be done solely by deputies. But in terms of the specific context of this case, the question of whether there could be zero is truly not before this court, because in the context of this case, on this record, that is a hypothetical question. Neither of the two.
I'm not asking that. It doesn't seem hypothetical to me to say that there is a circumstance provided in subdivision 2B3 which specifically calls for election judges to perform a certain action. But if you don't have any election judges, how can you comply with that part of the statute? It seems to me you can't.
I would argue that therefore the statute is ambiguous because the statute contemplates deputies doing that work, and mandamus is not the vehicle to clarify an ambiguity. I do see the point Your Honor is making, but again, I'm going to fall back on what is the question before this court. The question is, did the lower courts err in denying mandamus? And mandamus does not issue based on a hypothetical. You are not faced with a situation where either of the respondents had zero election judges.
Counsel, how does Ramsey County define sufficient number of election judges?
Ramsey County defines a sufficient number of election judges as enough to count the expected number of absentee ballots. And it is our custom to rely the vast majority on election judges rather than deputies.
And
but
I want to just ask you about the relevance, if any, of subdivision 1C. The language in the statute there says, except as otherwise provided in this section, all provisions of Minnesota election law apply to a ballot board. What's the relevance of that sentence?
I believe the relevance is it does state that the election judges have to be appointed as per the general election rules, but I don't think it precludes the next sentence of the statute, which says that deputies can be used.
Wouldn't it be more reasonable to just read the statute as, if you're going to use deputy auditors, they are also election judges?
No, Your Honor, I don't believe so, and we've cited this legislative history in our brief. The legislature actually considered amending the statute to say deputies acting as election judges. They struck out that language and instead inserted the language deputies trained in the processing and counting of absentee ballots. So to interpret the way that Your Honor is suggesting would be to read language back into the statute that the legislature expressly rejected, and I respectfully submit that the court should not and does not do that based on its precedent. You do not read language in that you know the legislature has rejected.
Does the structure of the statute that says you must appoint election judges and then you may appoint deputies tell us anything about the priority? And this is going to the exhaustion issue, kind of the preliminary issue of whether you have to, which it appears you did, but that you have to exhaust the party lists before you can get to appointing deputies. I mean, because one is must and one is may. One's permissive and one's mandatory.
Your Honor, I do agree that creates an ambiguity, but again, ambiguity means that mandamus should not.
And what authority do you have for that, by the way?
The courts
we have cases where we've had ambiguous statutes create a.
I'm not aware of any case where this court has said mandamus should issue based on an ambiguous statute. I'm relying on the case law cited in our brief, which says the duty must be clear and not.
But if we say what the statute means after resolving ambiguity, isn't that a clear duty? Don't we get to say what's clear?
I think, I would argue not in a case where the question before you is whether mandamus should have been
So your position is if it's
issued.
if it's ambiguous, you can never have mandamus?
That would be my argument, Your Honor. And then in terms of the word must, as Your Honor pointed out in your questions to opposing counsel, that word is modified by sufficient. Must consist of a sufficient number. And the court should not read that word sufficient out. There could theoretically be a situation where...
So you said it has to be sufficient to count the ballots.
Yes, and
so
there could...
you say that's 67. I mean, I think that's a different question. You make that it's in your discretion to say it's 67 or whatever number you come up with is sufficient. But once you figure out what that number is, that doesn't necessarily mean you don't have to exhaust the party lists to get to 67 before you move on to other things. I mean, those are two separate questions, right?
Your Honor, on the exhaustion issue, and I'm out of time, but I want to answer your question. On the exhaustion issue, the legislature has specifically said, thou shalt exhaust when appointing judges to a precinct. If they wanted to say similar, impose a similar requirement, I respectfully submit they would have said, do that also for ballot boards. There is
But
no...
didn't they say 204B.19 to 22 in the statute? I mean, which talks about exhaustion. So you're saying because it focused on precincts in the other statute that's referenced.
Yes, they specifically say in precincts, and again, that would be mandamus based on a hypothetical, at least as to Ramsey, because the unrefuted evidence in the record is we do exhaust. I am out of time, so I'm going to yield to my co-counsel. Thank you, Your Honors.
Thank you, counsel. Ms. Plant, you will have 12 minutes. Don't worry, that happens to almost everybody.
I think I can get it back on.
Yeah.
Good morning. May it please the court and counsel, my name is Jennifer Plant, and I'm here representing Olmsted County, its Board of Commissioners, and its Director of Property Records and Licensing. And before I proceed, Chief Justice, did I understand that I will not have the 3 minutes?
Correct.
Okay, thank you.
What do we do with the fact that Olmsted County doesn't have an auditor at all?
Well, Justice, I'm glad you asked that question, because that's something that actually is discussed in the facts section of all of my briefs with respect to the special legislation that occurred in 1998, where the Minnesota legislature authorized Olmsted County, if it so chose, to abolish both the office of the auditor as well as the treasurer. And it put in place several requirements that the Board of Commissioners had to comply with. All of those were duly complied with. The record reflects, and I can cite the number for you if you need, but it is in our addendum. Both the special act that allowed Olmsted County to do that, as well as the Olmsted County resolution dated December 7th of 1998.
But there's no position called an auditor. Like in some counties, they actually have an appointed auditor as opposed to an elected auditor. That's often how that special legislation, but Olmsted just did something different. So
that's correct, and that was authorized by the legislature in the act of, I think it was March 23rd.
Yeah, and so the legislature authorized it, but
Yes.
isn't one possible conclusion from that Olmsted County simply can't appoint deputy county auditors in the role in which was done here, and not you personally, but that the county needs to use election judges with the full requirements of the statute?
No. And the reason is because in the definitions section of the Minnesota election law, which is in a different chapter and refers back to Chief Justice Gilday's question about all the other provisions of the election law, 200.02 actually defines county auditor in subdivision 16. And in that subdivision, it says county auditor means the county auditor, or in counties where that office does not exist, i.e. Olmsted County, the principal county officer charged with duties relating to elections. So in Olmsted County, if you look at that resolution, which is on our addendum at page 5, in that resolution, it discusses which duties of the county auditor are going to be assumed by the director of property records and licensing, and then a different department was established, or directorship was established to handle the treasurer duties. But the election law actually contemplates Olmsted counties and other counties. I think Dakota County is similar, where they've abolished the office of auditor. And so there's explicit statutory authority that does allow counties where there is no elected auditor to use.
So if I understand what
deputies.
happened here, Olmsted County appointed 17 individuals as both election judges and deputy county auditors. And I'm wondering, A, what the authority is for that, given what the statute talks about in terms of election judges. And then B, shouldn't we be concerned about the fact that, at least in theory, now I understand Olmsted County says they did conduct some kind of an investigation from a partisan standpoint, but if I understand correctly, Olmsted County's position is they have the complete, absolute, unquestioned legal authority to never appoint an election judge and to have no partisan supervision of absentee or mail-in ballots. Am I understanding the county's position correctly?
No, Your Honor, you're not. The county is not stating or asserting that we have absolute authority to do anything. The court is here today to decide the question of whether the district court abused its discretion in denying a writ of mandamus. And in that particular posture, the requirement is that the appellants or the petitioners in the district court establish to the district court satisfaction that they are warranted mandamus relief, because there is no entitlement to that extraordinary remedy. You have to demonstrate that it's available to you, and then in his discretion, the district court can decide to do that.
Counsel, in the view of Olmsted County, how many election judges were sufficient?
I'm sorry, I missed the first part of that.
In the view of Olmsted County, how many election judges were sufficient?
I believe it ended up being about 26. It was 25, Your Honor. And the reason it was 25 was because in the initial resolution of July 21st, 2020, there were 17 individuals appointed, 19, excuse me, and then subsequently, prior to the election, the director determined that there were not sufficient number of election judges to accomplish the election duties because of the ongoing pandemic situation and requests for absentee ballots that were being made, and so he did.
So counsel, could sufficiency ever equal zero?
I think sufficiency potentially could equal zero, but I'm going to bring the court back to the idea that we're looking at whether or not there's a clear duty to appoint a certain number of election judges, and the answer to that question is no. There is no clear duty to appoint any election judges because the statute does not read the county board or the governing body must appoint election judges. The statute reads that the governing body must establish a ballot board,
Counsel,
which must consist of, yes, Justice Hudson.
Finish your answer to Justice McKay.
I didn't want to be disrespectful.
I know, I'm sorry, I cut my colleague off.
It states that the board must consist of a certain, or not even a certain, a sufficient number of judges. Consist is an inactive verb. There's no act that must be performed. And this court's mandamus jurisprudence states that mandamus lies where there's a clear duty to perform an act. Consisting is a state of being. It's not an act that can be accomplished. If the legislator wanted to impose a clear duty to act, the words should have been or would have been, the governing body must appoint a sufficient number of election judges. It did not say that. It said it must establish a ballot board, and then the board must consist of. Now, if that creates an ambiguity, Mandamus is not appropriate because there cannot be mandamus where there is no clear duty.
Isn't the language actually read, the governing body with responsibility must establish a ballot board which must consist of a sufficient number of election judges? I mean, you're breaking it into two sentences, but, I mean, the duty is to appoint a board that consists of election judges. And I don't see how you can square that with 0 election judges.
And respectfully, I disagree because the legislature created 2 separate sentences there, and the act that they required the governing body to perform is to establish the board. Now, I agree with you, it's difficult to reconcile, but that goes back exactly to the point, is that the court needs to look at the plain meaning of the statute.
Right, the plain meaning being how a normal person would read it.
That's right. That's
Which
right,
read
but
those two
also
sentences
applying
together.
certain canons of pre-ambiguity interpretation.
So
Counsel,
the period breaks it all up. The period means that there's really no duty to appoint sufficient judges.
There's no clear duty that would warrant mandamus relief.
Counsel, if sufficient can equal 0, then who does the work required under subdivision 2? I mean,
Well,
the subdivision 2 has specific things that election judges have to do. So if we're not going to appoint any election judges, then who does the work in subdivision 2?
well, there's an ambiguity there, Chief Justice, and that goes back to Mr. Rocha's point, which
There's
is that
there's nothing ambiguous about the mandatory duty of election judges in subdivision 2. The statute is very clear that election judges have to do X, Y, and Z as set out in subdivision 2 of the statute.
I believe there's one specific duty that can assuming Justice Thiessen's interpretation, and yours as well, Your Honors as well, there is one duty like that. But again, reading that particular provision in context, as we need to do with our pre-ambiguity canons of interpretation, we have to look at that one provision in the context of all of the other provisions in .121, as well as 204B.19 through .22.
I'm going to try my question again. If sufficient equals 0, then who performs the duties set out in subdivision 2?
Presumably the other members of the ballot board, which may be deputy auditors.
Counsel, in this case where we're looking at whether the district court abused its discretion, Olmsted County didn't have 0 election judges reviewing the ballots, is that right?
That's correct.
And again, can you tell me how many ultimately, I know some were added before the district court judge ruled.
There were 17, which was what I had originally stated.
And there's an affidavit in the record that the partisan balance between these election judges, there was no party with more than 50%, correct?
That's correct.
Counsel, some of my questions have already been asked by my colleagues, so I won't go there. But 2 things. One, just a clarification about the record. When Olmsted County, after they passed their resolution, I believe it was, at that point, there were no election judges. Am I correct? I mean, the election judges didn't come into the picture until after appellants brought their mandamus action, is how I read the record.
That's not correct, Your
Okay.
Honor. No. It's actually both in the appellate's addendum as well as ours, I believe, but we did have a resolution again on July 21st of 2020. And in the first portion of that, it establishes the absentee ballot board and lists 20 people to be deputies. And then it also, in provision 2 of that same resolution, appoints 17 of those people to be election judges. And there's overlap there. So,
Did they give their
But
partisanship?
I was just going to say.
yes, all of them did. And no party was represented by more than, I think it was actually even 25% of the election judges who were appointed.
Okay.
I just have a question. Oh,
No,
I'm
I
sorry.
had one
were
more.
you-
Thank you,
Okay,
Justice
yeah,
Stewart.
yeah.
This is really going to the Chief's question. If you look in subdivision 2, in that first paragraph, I think it's the last sentence, it says, the election judges performing the duties in this section must be from different major political parties. I would assume that you read that to mean election judges, if there are any. Because that same duty could be done by the deputies.
Yes.
Okay, so,
Those who are performing the
Right.
duties, if they are election judges, yes, must be of different major political parties. But again, and I see I'm almost out of time, this demonstrates, all of the court's questions here today demonstrate that the statute is in fact ambiguous.
well,
The
but what
appellants
do you
admit
do,
that.
though, with, I get that argument, but I'm still troubled by subdivision 2B3, which I think goes directly to the chief's point, where there, it specifically says it must be election judges that reconcile any discrepancies vis-à-vis signatures.
I agree. And again,
What do you
I
do with
don't know
that?
how to reconcile that because
Okay.
I'm not a legislator and we have to work with the plain language. And this actually explains why it is that there are multiple ways of doing this. And if I may have just another minute to finish answering your question about this, mandamus isn't appropriate to correct an issue that apparently is running rampant throughout the state, as counsel suggested earlier, that there's a multiplicity of ways that the statute is being interpreted. If that's the case, he's disproved his own case and theory, which is that it's so clear that we're entitled to extraordinary relief. No, it's not clear. It's wildly ambiguous in many different ways as far as what specific duties need to be performed. The only clear duty is the duty to establish a ballot board. There's no clear duty to appoint a specific number of election judges.
Thank you, counsel. Your time is, did you have something? No. Okay, your time is expired.
Thank you.
Mr. Joseph, you have 10 minutes for rebuttal.
Counsel, as you're approaching the podium to speak, I want to ask you if you can clarify this question of the availability of declaratory relief. Counsel for Ramsey County indicated that he wasn't aware of any other proceedings that the alliance had been involved in on declared. And I thought I read that somewhere, but maybe I'm wrong about that. Can you address that issue?
Sure, Your Honor. We don't have any waiver of sovereign immunity. We're going to run into a problem because the government hasn't consented to be sued in this context. We don't have any underlying right in 203B anywhere that demonstrates that any of our clients have a specific right to have this statute interpreted in a specific way. So,
has there been some other action on these issues that was in the form of a declaratory judgment proceeding that was rejected?
Your Honor, I don't have that in front of me. I apologize. Not to my knowledge. Not to my knowledge. But we do have case law we've cited in the briefing that demonstrates that a declaratory judgment without the vindication of an underlying right is inappropriate. So we're going to run into a problem with a sovereign immunity claim, Your Honor. So I'll pick up from there, Your Honor. I want to mention that because we have a misapplication of the statute, that's not evidence of a lack of clear duty, Your Honor. It's still not clear what authority we're talking about. We're not clear what authority that Ramsey or Olmsted County is talking about when they create these deputies to begin with. But we do have clear duties in this statute. First, we need a ballot board that must consist of deputies that can't be the number 0. The deputies have to be appointed pursuant to 204B19 through 22. And that includes declaration of party affiliation. In terms of unique harm, our client, the Republican Party, has an expectation that its list be exhausted.
On that point, in Olmsted County, when they did the 17, was that taken off the party lists?
No, Your Honor, they did not exhaust the party list. And I wanted to, if I could read the resolution. This is part of the record as well, obviously, but the resolution adopted by Olmsted County is bizarre, in a word. We have the following resolved. Whereas the absentee ballot board would consist of Olmsted County election staff trained in the processing and counting of absentee ballots as provided in 204B19 to 22, who have been appointed to serve as deputy county auditors by the Director of Property Records and Licensing, pursuant to 38408 and County Resolution 98-131. Now, we have the actual language in the resolution below, which we have the Olmsted County Board of Commissioners establishing an absentee ballot board for the 2020 primary and general election consisting of all members of the Olmsted County Property Records and Licensing Elections staff that have been appointed as deputy county auditors by the Director of Property Records and Licensing. We have some overlap between this list we see on the second page of the resolution and the third, where we have someone, the county board, appointing the following individuals to serve as election judges to perform election-related duties assigned by county elections staff on behalf of the county auditor. We then have a list of names that, again, overlap significantly with the deputies that we saw in the first portion of the resolution. Again, it's not clear where the authority came from. We see they declare it was 38408 that these people were appointed pursuant to, as well as County Resolution 98-131. That takes us right back to the same issues we had before. First of all, we have a county board who's appointing people to perform duties for a county auditor that the county auditor is not authorized to perform under 38408. We then have, I'm sorry.
Sorry to interrupt you. I wanted to ask you about the administrative rule that the Secretary of State has promulgated, 8210.2450, which in subpart 1 appears to exempt deputy county auditors and deputy city clerks from the party balance requirement of the statute. And I'm wondering whether that's a enactment that we should be looking to is an indication of what the appropriate interpretation of the statute is in deciding this case.
We absolutely don't believe that 8210.2450 is an appropriate interpretation of this statute. That could well be the subject of future litigation. But the problem, again, I want to mention it even though you didn't directly ask the question, we couldn't have brought this under the Administrative Procedures Act to address this statute. The only possible remedy we have in this case is a writ of mandamus.
Wasn't the administrative rule actually the subject of a case that ended up getting dismissed because of a lack of standing to bring that argument by the Court of Appeals?
In this case?
Yes.
Again, we can't attack 203B121 through 8210.2450. To get to the underlying duties in this statute and to request the relief we need, we have to, this is how we had to do it.
I also wanted to follow up and ask you about what you believe the appropriate definition is for deputy county auditors here. There's some suggestion in your brief that the counties have appointed non-bona fide or counterfeit deputy county auditors. Where does the authority, well, I know where the authority to appoint comes, but in terms of the definition, could you help us out in terms of, what is a bona fide deputy county auditor in your mind?
Thank you, Judge, for asking. We would argue that the idea is that a deputy county auditor is supposed to be somebody who's a pre-existing person. This isn't supposed to be someone who's brought into existence for the sole purpose of displacing an election judge or occupying a ballot board. And if that were the intention, we would expect to see some procedure laid out in 203B121 or somewhere in 204B19 through 22, and we don't. As a matter of fact, we see nothing in the entirety of the election law that suggests that. So what we would argue is that the idea of a bona fide or a pre-qualified or a pre-existing deputy county auditor, and the reason legislature used that language is because it was a limiting factor. It was to give local governing bodies the option of including people on the ballot board from a pre-existing pool of people who are qualified and appointed under 38408 to do the duties of the principal county auditor in the first place. And again, they could have chosen any language. They could have chosen staff. And in 2013, they chose to excise staff from this. So the choice of using a deputy county auditor, we would argue, has a meaning, and it has to come from somewhere. So that's why we think a bona fide or a pre-existing deputy is someone who can perform the duties of the actual county.
Counsel, isn't this, robust discussion that we've had here today, in and of itself, proof that this really is a legislative matter, that there is no clear duty, that if there's fixes and tweaks to be made to the statute in light of the growth of absentee ballot voting, and all that means or doesn't mean, depending on how you look at that, that this is something the legislature needs to deal with, where all the various stakeholders can come in, make their pitch, look at all the data, look at what was done, try to determine, talk about the integrity of elections and all of that. It just seems like it's not our job.
Your Honor, I think this court can harmonize all the parts of this statute. I don't think there are that many moving parts that are missing. I think if we treat these deputies...
Yeah, but the ones that are missing are pretty significant. We'd be wading in.
Your Honor, if we treat ballot board members as ballot board members, and we treat deputies as having to be appointed the same way election judges are appointed, under 204B19 through 22, we're there, Your Honor. We have the clear...
But the problem is that first paragraph of subdivision 1, to me, clearly separates the two. And so...
I understand, but again, and it takes us back to the same problem we discussed before, which is why don't we see anything else in the statute that recognizes these two groups of people?
Counsel, I'm wondering if these two defendants in this proceeding, Ramsey County and Olmsted County, aren't in different postures, maybe resulting in a different outcome. And I note specifically that Ramsey County exhausted party lists, Olmsted County didn't. And Olmsted County appointed these 17 individuals as both election judges and deputy county auditors. Is there an argument here that, from your perspective, Olmsted County might be in more difficulty than Ramsey County, or do you see them as similarly in violation of the statute?
I see them similarly in violation of the statute, but in different ways. But really, underlying your question, Your Honor, is we have disparate applications of this statute. We have two different counties applying this statute in two different ways, and this is going to continue unless hopefully this court makes the right decision and figures this out.
Thank you, counsel. Your time has expired. Thanks
Thank
to
you.
all counsel for the help you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course.